Hi, it's me again, Marcel, Jude, and we are continuing to look at the domestic violence, which, due to the current movement control order, there has been probably a slight increase or even a major increase in cases. But this is understandable as people are confined to a limited space 24/7, and so their emotions are going to be released, but then there is a law that prohibits you from using violence or violent methods just because you feel bored, you feel that the longer you are in a confined space, that does not mean you can take the law into your own hands, or even commit acts which are acts of violence or oppression in your home. Now, in today's in this video, we will look at interim protection order and protection orders as far as we can. First of all, we look at restraining and restriction orders, where the order made as to the right to occupy the shared residence or to enter the alternative residence is suspended or restricted or prohibited or restrained. The order will not affect any title or interest that the person against whom the order is made or any other person might have in the said premises. In other words, the restriction or restraining orders that a court can make does not do anything or will not affect the ownership of the property. The purpose of the order is merely to ensure safety of the person who may be a victim of the domestic violence. It does not mean that if you're excluded from the property because you have a tendency to undertake violent acts, if an order is made that you cannot enter such a property, it does not mean that the property is transferred to the person who may be a victim. What the courts want to do is prevent violence or taking place. So when they issue such an order, it does not affect your ownership. You may be a joint owner or a full owner of the said house, the matrimonial property or whatever it may be. Being excluded from the property does not mean you lost the right of ownership, but it will affect your right to be in the premises. Maybe we can say that it affects your right of possession. Okay, in making the order to exclude a person from a shared residence which is solely or jointly owned or leased by him, the court may not make the exclusion from the whole of such residence unless it is satisfied that there is no other way to secure the personal safety of any protected person for the time being. And such an order will be, number one, revoked if a suitable alternative residence is found for the protected person or persons, or number two, revoke or modified upon the court being otherwise satisfied that it's no longer necessary for securing the personal safety of the protected person or persons. So basically what it means is the court does not want to make an order to stop you from entering your own property. If let's say you're a violator and you have a tendency to undertake acts of domestic violence, the court is not trying to prevent you from excluding you from the whole of your property. It can make orders like you only can occupy, in the case of say a double-story house, you can only occupy the upper story, while the lower ground story is for the person who's a victim. But if in the case that there's no other way, then it may make the order saying that you cannot occupy the whole of the house. You may have to find another residence, or for the time being, while the order is in place. Injunction against molestation and exclusion orders. This is another type of order. Injunction against molestation may be issued by the court under the Law Reform Marriage and Divorce Act 1976, and the court has the power during the pendency of any matrimonial proceedings, or on or after the grant of a decree of divorce, judicial separation, or annulment, to order any person to refrain from forcing his or her society on his or her spouse or former spouse, or from other act of molestation. Although there is no provision in the Law Reform Marriage and Divorce Act 1976 for an exclusion order, the court may apply the provisions of the English Domestic Violence and Matrimonial Proceedings Act 1976 and grant such an order. So when there is a decree of divorce or judicial separation or annulment of a marriage, the court can issue an injunction excluding you or preventing you from molesting your spouse or former spouse. Next, we turn to another aspect of the Domestic Violence Act, which is the power of arrest. If the court is satisfied that the person against whom a protection order or interim protection order is made is likely to cause actual physical injury to the protected person or persons, the court must attach a power of arrest to such protection order or interim protection order as the case may be. If a power of arrest is so attached, the police officer may arrest without warrant the person against whom the order is made when one or more of the following situations arise. There are three types of situations. Firstly, when there is a report of domestic violence lodged by a person who is protected under the interim protection order or protection order to any police officer. Secondly, when the police officer has reasonable cause to believe that the person against whom the order is made is in breach of the order. And finally, when the person against whom the order is made enters into any place prohibited under the order. If a power of arrest so attached to a precaution order, okay, I have to cough here because it's not easy to breathe with this thing on and talk. But since I don't want you to get any virus while you're watching this video, we have to keep the mask on. But you don't have to keep a mask while you're watching this video because the virus won't spread to you. But coming back again, if a power of arrest is so attached to a protection order or interim protection order, and the person against whom the order is made is arrested, he must be brought before a judge or a magistrate within 24 hours of his arrest, and he may not be released within that period except on the direction of the judge, and he may not be detained after the expiry of that period. So anybody who is arrested under this order, they must be brought before a judge or magistrate within 24 hours, and within the 24 hours they must make a decision, the judge, whether he's to be detained. If there's no such decision, he must be released. Next, we turn to contravention of the protection order. Any person who willfully contravenes a protection order or any provision thereof will be guilty of an offence and will, on conviction, be liable to a fine not exceeding Rm 2,000 or to imprisonment for a term not exceeding 6 months, or to both. In other words, you can have three types of sentence. One is fine not exceeding 2,000, or secondly, imprisonment for a term not exceeding 6 months, not more than 6 months, or a fine and imprisonment. Any person who willfully contravenes a protection order by using violence on a protected person will, on conviction, be liable to a fine not exceeding 4,000 or to imprisonment for a term not exceeding 1 year, or to both. Okay, this is more serious than the previous contravention where you use violence. In the first one is you contravene the protection order. Maybe you're not supposed to go to that place and then you go, but you didn't make any threats. But in the second one, the most serious one, you go and see the protected person and you use violence on that person. So then you get a heavier fine, which is 4,000, not exceeding 4,000, or imprisonment 1 year. The last one was 6 months, or both. Any person who is convicted for a second and subsequent violation of such protection order will be punished with imprisonment for a period of not less than 72 hours and not more than 2 years, and will also be liable to a fine not exceeding Rm 5,000. So this is a repeat offender. They will give you a bigger fine or a more larger detention period, okay, or both. Now we turn to the making or renewing orders upon contravention of protection order. If a person against whom a protection order has been made contravenes the protection order, the court may, in addition to any penalty provided for, make or make anew, as the case may be, any one of or more of the orders to commence from such date as is specified in such new order. What this means is that the court can extend protection order if they feel that you still haven't learned their lesson, you still want to continue to threaten, then they have no choice but to extend. Now, what about the case where you haven't proved that the person is an offender, but the police is doing investigation, so they need to sort of maintain the status quo. That means they need to make sure that while the investigation is being undertaken, because you must understand, under the law, everyone is innocent unless proved guilty. Okay, so just because somebody said, this person is committing violence, or I'm fearful for my life, doesn't mean that the allegation is true. It has to be proven. But how about the time between the investigation and the time between the charging of the person? It's no point if what the accuser says is true, and then while the investigation go on, then violence takes place and damage is done. It's too late. So there's a thing called interim protection order. The court may, during the pendency of investigation relating to the commission of an offence involving domestic violence, issue an interim protection order prohibiting the person against whom the order is made from using domestic violence against his or her former spouse, or a child or incapacitated adult or other member of the family as specified in the order. An interim protection order must be made by way of an application to the court. The court, in making an interim protection order, may include a provision prohibiting the person against whom the order is made from inciting any other person to commit domestic violence against the spouse or former spouse, or a person or an incapacitated adult or any other member of the family, as the case may be, against whom the order is made. An interim protection order will cease to have effect, firstly, upon the completion of the investigation, or secondly, when the criminal proceeding relating to the commission of an offence involves domestic violence is instituted against the person against whom the order is made. Sorry, I'm going a bit fast because number one, this video is taking a bit too long, and number two is I'm really running out of battery. Protection order. But anyway, I think you know what an interim protection order is. It's just to maintain the status quo and protect the person while investigation is ongoing. Protection order. Now we go to protection order. The court may, on application involving a complaint of domestic violence, issue one or more of the following protection orders. There are three types of protection order. Firstly, a protection order restraining the person against whom the order is made from using domestic violence against the complainant. Secondly, a protection order restraining the person against whom the order is made from using domestic violence against the child. Thirdly, a protection order restraining the person against whom the order is made from using domestic violence against the incapacitated adult. The court, in making a protection order, may include provision prohibiting the person against whom the order is made from inciting any other person to commit domestic violence against the protected person or persons. Okay, this refers to cases where the person committing the offense gets the help of other people and uses a third party a nominee to do the violent act without him doing it himself. So they want to avoid some of these clever offenders who use this kind of method. Okay, now the protection order is not just the order to prohibit violence. They also other orders, and these orders may be included in the protection order. I will just run through this. I hope I have enough battery because this is an 18-minute video, and it's going to be very difficult for me to start all over again. Number one, the granting of the right of the court, a protection order issued may be varied, where on a balance of probability the court is satisfied that it is necessary to do so for the protection and personal safety of the complainant or child or the incapacitated adult, and provide in the protection order for any one or more of the following orders. Number one, the granting of the right of exclusive occupation to any protected person of the shared residence or specified part of the shared residence by excluding the person against whom the order is made from the shared residence or specified part thereof, regardless of whether the shared residence is solely owned or leased by the person against whom the order is made, or jointly owned or leased by the parties. Okay, so in the order itself, they can put a provision that you cannot go into the premises of the house of the protected person. Number 2, prohibiting or restraining the person against whom the order is made from A. Entering any protected person's safe place, shelter, place of residence, or shared residence, or alternative residence as the case may be. B. Entering any protected person's place of employment or school. C. Entering any other institution where any protected person is placed. D. Going near any protected person at a distance of at least 50 meters or at a distance that the court thinks reasonable. Or E. Making personal contact with any protected person other than in the presence of an enforcement officer or such other person as may be specified or described in the order. Then the third type of order is requiring the person against whom the order is made to permit any protected person to enter the shared residence or re-enter the residence of the person against whom the order is made, accompanied by an enforcement officer for the purpose of collecting the protected person or person's personal belongings. Okay, like you're allowed to stay in the residence, the offender, but some of the items belonging to the protected person is still there, so they can make an order that that person can go and collect those items. 4. Requiring the person against whom the order is made to avoid making communication by any means with any protected person and specifying the limited circumstances in which such communication is permitted. Okay, so you cannot make phone call, cannot contact on internet, cannot send WhatsApp. These orders also can be made. Requiring the fifth one, requiring the person against whom the order is made to permit any protected person to have continued use of a vehicle which was previously been ordinarily used by the protected person or person. Okay, dispute may arise as regards to the use of the car, which is previously family car, but now because of the dispute and the protected person still needs use of the car, so they can make such order. You cannot the offender cannot have absolute use of the car to himself. Okay, next one, number 5, requiring the person against whom, number 6, the giving of any such direction as is necessary and incidental for the proper carrying into effect of any order made under any of the above mentioned provisions. Okay, so the court can make orders as required to it can customize the order made to the particular situation, in addition to the orders already mentioned above. The above mentioned orders will have effect for such period not exceeding 12 months from the date of the commencement of the order as may be specified in the protection order. So it's for a 12-month period. Any one or more of such orders may be made or made anew upon the contravention of a protection order. Okay, so if you breach, they can extend the 12 months, or be extended for such further period not exceeding 12 months from the date of the expiration of the original order. So the 12 months is not absolute, it can be extended, but the grounds is where the court is satisfied notwithstanding that there has been no actual contravention of the order, such extension is necessary for the protection and personal safety of the protected person or persons, but such extension of order will not be made for more than once. Okay, so that is what the protection order can do. And now I have to end. Thank you. See you again. Bye.